So you concentrated on compliance with internal processes.
And
the second period that you refer to is 2009 to 2012, mid-2012. What were your functions then?
Chair, so during that period I was the Group Head of Internal Controls, so I provided oversight of that outsourced internal audit contract, as well as the process improvement function, and it had some forensic elements, but we had another manager looking after the forensic function.
And then who did you report to during that period?
So during that period, Chair, I reported to Anoj Singh.
Right. And what was his position at that time?
Chair, at the time he was General Manager Group Finance and Acting Group Chief Financial Officer, and he was also made permanent during that period, if I recall.
Right. And then the third period, from mid-2012 to April 2013?
Chair, so I was still in the, I still reported into finance or into the internal control department to Mr. Singh, but we had a information security incident, which we were quite concerned about, and because I had both finance and technology background experience and skills, Mr. Singh asked me to sort of spearhead or address that issue and see if we can get it resolved.
And at that time, did you have to work with and become involved with particular suppliers to Transnet?
Chair, I had to, absolutely. At the time, our data center was outsourced to T-Systems, and our network was outsourced to Neotel. So I was heavily engaged with those two vendors.
We will deal with that in more detail by way of introduction in a moment.
Sure.
And then from April 2013 to December 2014, what was your function?
Chair, so after that period, I joined the ICT, what's also referred to as the Enterprise Information Management Services Department, and my role was Office of the CIO, which was predominantly to support the CIO and look at overseeing ICT procurement, vendor management, look at the finances of IT, with some other elements. Vendor management, I think I mentioned, I think those are the most important ones in that role.
And your evidence will concern issues related to ICT, or Information Communication Technology procurement.
That's correct.
And the management of the processes that were involved.
Correct.
Right. What was your title at that time?
Chair, it was Office or Executive Manager, Office of the CIO. But like I said, it was also referred to as Enterprise Information Services.
And to whom did you report in this capacity?
Chair, initially we had an acting CIO, a gentleman by the name of Ken Jarvis. So initially I reported to him. We then appointed Dr. Mansika Matuane, who I reported to after that.
Now, before going into the substance of your statement, it's necessary, as we discussed this weekend, to provide the chair with some background. Otherwise, the functions and the procurement in relation to Neotel and IT systems can become confusing. Terms like centralization, for example, can become, or concentration can become confusing unless one understands the background. Before Ms. Ramos became Chief Executive Officer or Chair, she was Chief Executive Officer, is that right?
That's right.
Of Transnet. And during the period she held office, in the Transnet stable were a number of entities. And as I understand the position, and it's not controversial, it was decided in Transnet to dispose of non-core assets so that it could concentrate on being a freight logistics business. Am I correct?
That's correct.
Now, two entities that existed within the Transnet stable are relevant to your evidence. The first is Arivia, ARIVIA.com. Is that correct?
That's correct.
That was disposed of.
That's correct.
All right. What was Arivia.com, or what function did it perform within the Transnet stable?
Chair, so Arivia.com was the owner of our data center, which included all of our servers and information and data assets. So they were responsible for the assets and the services linked to those assets.
So Arivia.com, a separate entity within the stable, was owned and operated all the, can we term it for want of a better word, hardware, on which all the data of Transnet was kept.
Hardware and software, I would say, Advocate.
Hardware and software. But that's all the computer-based information, the electronic-based information used or which was necessary for the operation of Transnet, was centralized under the auspices of Arivia.com.
That's correct.
Both assets and operation.
Yes.
And then Transtel.
Transtel, Chair, was the network services provider. So they were responsible and owned all of our fiber assets, copper assets, routers and switches that enabled all of our applications and individuals to talk to each other
All right. So you have the data in the data center, that's Arivia.com.
Yes.
But now this data has to spread between the various operations and entities within the Transnet stable.
Correct.
The communication network, in other words.
That's correct.
Cabling. Would you give the Chair an idea of the amount of cabling that Transnet ultimately had to deal with?
Sure, Advocate. I think it's just important to distinguish. There were fiber rings in the metropoles, as you can call it, then regional lines, so from Johannesburg to Durban, Cape Town, that kind of thing. And then you had significant fiber and copper assets within what we refer to as Transnet campuses. Those would be ports, rails, and although we don't have an exact number, and we also didn't have perfect designs, the number quoted was between 8,000 and 9,000 kilometers of fiber in the Sandton campuses. In the Transnet campuses, sorry.
So electronic communications within Transnet involved substantial infrastructure.
Absolutely.
Substantial assets, including the switches and routers necessary for this electronic communication to take place. And buried, as I understand from you, buried under the tarmac and the ports and in other places was 9,000 kilometers approximately of cabling.
That's correct.
Now, as I understand your evidence, a decision was made, and this again is not controversial, to dispose of both businesses on the basis that they were not core to the operations of Transnet. Is that correct?
That's correct, Chair.
Right. What happened then pursuant to that decision? Were they disposed of?
Chair, they were disposed of, yes.
And was that through an organized process?
Chair, yes, although I wasn't intricately involved, it was competitive processes from what I recall. So we went to market, and T-Systems was the successful bidder for the data center or Arivia.com piece, and the newly formed Neotel was the successful bidder for the network.
So Neotel, which is a PTY limited company as I understand it, purchased Transtel.
That's correct.
So Neotel then purchased both the business and assets of Transtel, which was, as you've just described, the network, communication network, right? And you say T-Systems purchased the business and assets of Arivia.com.
That's correct.
So at a stage after this disposal of assets, disposal of entities, you have Neotel operating the network, previously operated by Transtel, and it now owns the relevant assets. Am I correct?
That's correct.
And T-Systems took over the business of Arivia.com. That is the data, the central database, the hard drive and software containing all Transnet information. Am I correct? I'm simplifying, but it helps.
That's correct, Advocate.
And it now operated and owned what Arivia previously had operated and owned.
That's correct.
All right. And this, around what time did this transfer of business occur?
Chair, if I recall, they were roughly a year apart, and if memory serves, it was 2008 and 2009, the two transactions.
Just bear with me a moment, Chair.
So you say the two transactions occurred in 2008, 2009?
That's
that
right,
kind
Chair.
of time. That is the purchase of Olivia.com by T-Systems and the purchase of Transtel by Neotel Pty Limited.
That's correct, Chair.
Okay, thank you.
Let's move to paragraph 6 then of your statement, if we may. There you talk of the period 2007, January, to December 2014. That is the period which is covered by your evidence. Am I correct?
That's correct, Chair.
And 3 contracts, or at least 3 contracts, we will discover, are relevant for your evidence during this period. What are those contracts?
Chair, the 3 relevant contracts are the 2007 Master Services Agreement between Transnet and Neotel. The second transaction was the procurement of Cisco equipment. And lastly, the 2004 Master Services Agreement between Transnet and Neotel, and linked to that, the asset buyback agreement.
All right. Now we need to understand then how Cisco becomes relevant. And we need to understand what master services agreements you're referring to. Remember, you've just told the Chair that these businesses were transferred from Arivia and Transtel. I think you mentioned 2009. But in 6.1, we're talking about a 2007 Master Network Services Agreement.
Then I'll probably mistake, and I know it expired on March 31 March 2013, if I recall. So it's probably correct then, Chair. Beg your pardon, it's 2007. Thereabout it appears, yes.
Right. So we may have to correct that.
Yes, I can
Get
double
a
check.
precise date for the agreement
Correct.
in 2007 or 2009 in paragraph 6.1. But what master services agreement was that?
So, Chair, as part of the sale agreement of the network assets to Neotel, there was a 5-year master services agreement which enabled Neotel to provide services to Transnet, network services.
Sorry, just before you go on, that's Neotel purchasing Transtel,
That's correct.
the network.
That's correct.
Okay, just go on, please.
So the link to that sale agreement was a 5-year master services agreement, which allowed Neotel to provide services back to Transnet at obviously a cost, just to sweeten the deal and to make it worthwhile.
So the business of Transtel goes to Neotel,
That's correct.
plus the assets.
That's correct.
But Neotel must now continue providing these services and using these assets for the benefit of Transnet.
That's correct.
And those obligations, or the obligations relevant to that particular transaction, are contained in the Master Network Services Agreement referred to in paragraph 6.1. Am I correct?
That's correct, Advocate.
Then the Cisco equipment. Now we're going to have to take a step back here because Cisco becomes important in your evidence. At a stage, it must have been contemplated prior to the Master Services Agreement being entered into, that you refer to in paragraph 6.1, that the life of Transtel is going to come to an end, and Neotel is going to step into its shoes. Is that correct?
That's correct.
It was also contemplated that a business would go to T-Systems.
Advocate, are you referring to the 2014 agreement or the 2007 agreement?
Now, I'm talking about the 2007 agreement. I just want to introduce Cisco.
Yes, I think that was more linked to the 2014 agreement,
Well,
or the expiration of the 2007, if I'm understanding you correctly.
yes.
Okay.
So, at a time, the contract between Transnet and Neotel that had been entered into in 2007 or 2009 would expire.
Correct.
That was the Master Services Agreement you refer to in 6.1.
That's correct, Chair.
And at a time, the Chair has been told, and will learn again, that it was contemplated under the management, really, or series of decisions made by, amongst others, Mr. Brian Malefi, that that whole business would go to T-Systems.
That's correct.
And of course, the assets underlying that business, all the cables and the switches you've talked about and the routers, they would have to then go to T-Systems in order for the business of Transnet to continue. Am I correct?
That's correct, Chair. They need assets to provide the service.
And you've already told the Chair that all those assets had been bought 5 years earlier by Neotel.
That's correct, Advocate.
They belonged to Neotel.
Yes.
But there were problems. What was the essential issue? Was Neotel willing simply to hand these over to the new incumbent,
Chair, no, they were not.
T-Systems?
We did engage with Neotel, and they formally advised me that these assets were securitized, or their lenders they couldn't sell these assets because they've borrowed money, and these assets were securitized.
In other words, belonged to the bank,
Correct.
pledged to the bank,
Yes.
pledged or under what ceded or whatever contract that was, but they couldn't be sold to Transnet or to T-Systems because the bank had them,
So
in simple terms.
yes, Chair.
Right. And there was an exclusivity clause in the arrangement, the 2007 or 2009 Master Service Agreement between Transnet and Neotel. What was that?
Chair, so what that exclusivity clause basically forced Transnet to do is any network equipment that we would need to buy, whether it be routers, switches, fiber, we have to buy from Neotel.
Transnet would...
I'm sorry, Mr. President. I take it that it follows from that statement, that decision, that even if there was somebody else who had what you were looking for, if Neotel had it, then you were bound, or Transnet was bound to get it from Neotel.
That's correct, Chair.
Yes, okay.
But Neotel wasn't the supplier, the original equipment manufacturer of the relevant equipment now needed by Transnet and now needed to be used by T-Systems. Perhaps you should just explain to the Chair the vulnerability that was experienced by Transnet because remember under the 2007 MSA Master Services Agreement, all its infrastructure from an electronic communications point of view was now owned by a service provider.
That's correct, Chair. So due to the decision to award the business to T-Systems that you've heard about, that would have entailed a network transition from Neotel to T-Systems. I think like the advocate has articulated, all those assets were owned by Neotel and they were not willing to sell them. So it was almost impossible for any other service provider to provide the services unless they lease or buy those assets from Neotel or if we replace the assets. The effort and cost to replace those assets would have been astronomical and was almost not an option. And we also had a fairly short period of time to transition the network from Neotel to T-Systems. So we were being proactive, and we, in discussions with Cisco and Neotel T-Systems, realized that a lot of the equipment was approaching end of life and end of software support. So we decided to buy that equipment through Neotel at that point due to the exclusivity clause, and to start installing that equipment to pull the transition forward, or to make it slightly possible to transition the network from Neotel to T-Systems.
Now, the supplier of this necessary equipment for the business of Transnet to continue from an electronic communications point of view, who was that supplier?
It was Cisco, too.
So Cisco had to supply the equipment, but it had to go via Neotel to Transnet.
That's correct.
Because, as I understand your evidence, Transnet decided no longer must a supplier or a service provider own our equipment, we must own it. That was what Transnet decided, is that not so?
That's correct, Advocate.
So Transnet had to buy, but via Neotel from Cisco.
Correct.
And there were various pricing arrangements relevant to these transactions about which you're going to testify.
That's correct.
Perhaps you can explain one thing to the Chair. It seems rather bizarre. You talk about 9,000 kilometers of cabling, network cabling, buried beneath the tarmacs in the ports, for example. This cabling is owned, or was for a period owned by the service provider Neotel. Did that make sense?
In my opinion, Chair, it didn't make sense. I thought it exposed Transnet to significant risk.
Could Transnet just not say, there's the cabling under my tarmacs and my ports, we're just going to use it?
Chair, well, it's not that easy, because Neotel can switch off our network effectively, block IP addresses and technical things like that to prohibit us from using that infrastructure.
So, in other words, you were extremely vulnerable.
We were a captive client, extremely
You were a
vulnerable.
captive client.
That's correct, Advocate.
And your bargaining position in relation to any change of this arrangement, was that strong, weak?
It was particularly weak.
And how long was the period during which this network was owned by Neotel?
Chair, so they owned it for 5 years as
Yeah.
part of that first master services
Contract,
agreement, and we'll get to it a bit later, but there was an agreement for us to buy back
Yeah.
relevant portions of those assets.
So that is the agreement you referred to in paragraph 6.2, procurement of Cisco equipment, the Cisco transaction.
That's correct.
Correct? And we've described how that came about and given some background to enable us to understand the evidence you give in relation to that later. Is that correct?
That's correct.
Let's just do the same exercise briefly in relation to 6.3. That is the 2014 Master Network Services and Asset Buyback Agreement.
Chair, so like I mentioned, there was a 5-year agreement referred to as the 2007 Master Services Agreement between Transnet and Neotel. That was reaching expiration date, and we had to go through a process to onboard whether it's the new or different or the same supplier, for another period of 3 to 5 years. So it was really a new contract for the ICT network services.
All right. But now, as the Chair has been told by previous witnesses, and you will repeat it and give some detail as to what happened in these transactions. In 2014, for a period of time at least, Neotel was to lose this contract. Correct?
That's correct.
And the contract was to go to T-Systems.
That's correct, Chair.
Right. Now, quite apart from what would happen to all the assets and infrastructure between Neotel and T-Systems, we can park that for the moment. But T-Systems at a time fell out of the picture. Correct?
Correct.
Neotel comes back on board. This is in 2014. But as you say, at this time, Transnet is aware of its extreme vulnerability if it doesn't own the infrastructure and the assets which Neotel now is going to operate or continue to operate.
That's correct.
Correct. So what does it decide to do?
So I think, Advocate, if I understand you correctly, so the strategy for Transnet was to repurchase, whether from Neotel or new, all the assets in what we refer to the Transnet campuses to alleviate that risk.
So now Neotel is going to come back on board. It's going to continue to provide the services, but Transnet says, look, we're too vulnerable if you, Neotel, continue to own the assets. We want to own the assets. We want to buy back the assets which we sold to you in 2009 or at around that time.
That's correct, so that we won't continually be a captive client.
And that's the buyback that you're going to refer to in your agreement, in your evidence.
That's correct.
Okay. And that buyback was related to a 2014 Master Network Services Agreement.
That's correct.
You were integrally involved in the negotiation of that agreement.
Yes, I was.
And that's much of your evidence is going to speak to the conclusion of and the negotiations preceding that agreement.
Yes.
All right, so we can then go through by way of background. There may be some repetition, but Chair, I think it was important to deal with that background. Let's go to paragraph 7. In fact, I'm told by my junior that the date December 2007 is indeed correct. So what do you say in paragraph 7 of your statement?
So, Chair, what I'm effectively saying in paragraph 7 is that the agreement was concluded in December 2007, but effective 1 April to 31 March 2013.
So from effective 1 April 2008 until 31 March 2013, a 5-year agreement, Neotel having taken over from Transtel, as you've told the Chair, is now bound by a 5-year agreement.
Correct.
Signed in December 2007.
Yes.
But it now owns all the assets and it is performing the functions.
That's correct.
Correct. And that, you say in paragraph 8, and you make the point, which you've already made to the Chair, that after the sale of Transtel to Neotel in 2007, Transnet found itself in the unenviable position where its IT network, upon which it relied completely for the conduct of its business, was owned and managed by Neotel as an external service provider.
That's correct, Ed.
And that's that evidence you have given by way of background to the Chair.
Advocate, and if I can just make one correction there, you'll see I've mentioned before in that paragraph, these two processes ran concurrently, the sale of the assets as well as the 5-year master services agreement.
Were they contained in separate agreements?
From what I can recall, they were.
Okay. But they would obviously have run parallel because the one clearly depended on the other. You couldn't have a services agreement without owning the assets.
Correct.
Or without access to the assets at least.
That's correct.
Correct. All right. And then in paragraph 9, you, again, it's not central to your evidence, but it may come up later, so it's as well to place it on record now, that Transnet knew that the 2007 Master Services Agreement was due to expire in March 2013. That's the Neotel agreement, is that correct?
That's correct.
And so what did it do?
So, Chair, we acquired the services of a company called Zetacon to assist us with a strategy as to how we should go, whether we should go to market and how we should approach it taking into consideration some of these complexities in the asset ownership.
Right. And was a strategy developed?
It was, Advocate.
Was it approved by the board?
It was,
Transnet board?
it was approved by the Board Acquisition and Disposal Committee, from what I recall.
Were the services of another consulting firm employed at the time?
Yes, Advocate. We employed Gartner, who assisted us throughout the tender process and the conclusion of the MSA.
Right. Just a small formality, you can address the chair rather than
Sure,
me
Chair.
when you answer the questions. So, what was the intention of Transnet, given the pending expiry of the 2007 Master Services Agreement?
Chair, so the options open to us was either to extend that contract or go to market to find whether it be the same or a different service provider, but ultimately to get a new 5-year or 3 to 5 year agreement in place.
And the processes talked about in paragraph 9 with the 2 consulting entities, were these rapid processes, quickly finalized? Did they take time?
Chair, the Datacon process was reasonably rapid. We, like I said, the Gartner process extended all the way from assisting us with the RFP documents, going to market, negotiation of the Master Service Agreement. So that was a multi-year project.
And what did this necessitate, this delay?
So,
Because the Neotel contract is about to expire, remember?
Yeah.
So what had to happen?
so we had to agree on a strategy, whether we want to renew that Neotel contract or whether we want to go to market. And so that was, we also had to do the documentation for the RFP.
Yes, but in the meanwhile, whilst all this decision-making is taking place, the contract is about to expire.
Correct.
So was that, what happened to that contract in the interim period?
So, Chair, that necessitated multiple extensions of that original 5-year Master Services Agreement with Neotel.
The first extension was for how long?
Chair, the first extension was from 1 April 2013 to 30 August 2013, a 5-month extension.
Second extension?
The second extension was from 1 September 2013 to 31 October 2013.
And the third extension?
And the third extension was from 1 November 2013 to 31 October 2014.
The first extension, you say in paragraph 10, was approved by the board, although a longer extension had been asked for.
That's correct, Chair.
The second and third extensions, did those come much later down the line?
They did, Chair.
Were they also approved by the board at a later stage?
All the extensions were approved by the relevant authority, whether it was the board or the Board Acquisition Disposal Committee, yes.
Right. Just if you would have regard to the contents of paragraph 11 of your statement, and if you feel it necessary, tell the chair about the contents of that statement in that paragraph.
Chair, the ICT management team were extremely concerned around the proposed short-term extension of this contract, because we knew if we had to go to market, that process is normally a 6-month process if you're lucky. If we then conclude with a new bidder, a transition, well, firstly we'll need to enter into a new Master Services Agreement and all the items attached to that, that again is probably a 6-month process, and you would then have to go through a transition from the current provider to the next provider. So we recommended a 21-month extension to the Board Acquisition and Disposal Committee, well, to our executive committee at the time. They then only proposed a 15-month extension to the Board Acquisition and Disposal Committee, who only suggested a 5-month extension to the board. So we were very concerned about that.
All right. Ultimately, however, to the extent necessary, other witnesses may testify to that. We've just flagged that issue for the moment. We needn't go any further.
That's correct.
In paragraph 12 to paragraph 17 of your statement, you traverse evidence already given by principally Ms. Sharla Chetty or Sharla Pillay. That evidence was given last week.
That's correct, Chair.
It's not necessary, therefore, to repeat that evidence in any detail, but for the purpose of now placing your evidence in context, can we just go through very quickly the steps taken on the expiry of the 2007 MSA between Transnet and Neotel and the appointment of T-Systems to take over that business. Now, your evidence is substantial in relation to the events surrounding the award to T-Systems and how that arose. But to put it in context, what do you say in paragraph 12? What happened in 2013? Now remember, the MSA is coming to an end, right? So there's a decision to issue a request for proposals, an RFP, to initiate a tender process to bring on board a new service provider. Correct?
That's correct.
Right. And that authority appears in a memorandum from Mr. Anoj Singh and Mr. Gary Peter to the Group Chief Executive, Brian Molefe, or at least the request for that authority, the background to that authority.
That's correct, Chair.
Right. And at that time, Mr. Gary Peter was the head of Group Strategic Sourcing, and he reported to Mr. Anoj Singh in the latter's capacity as Group Chief Financial Officer. Correct?
That's correct, Chair.
And that request to initiate a procurement process to replace or re-employ Neotel was approved by Mr. Brian Molefe, am I correct?
That's correct.
What capacity did he hold at that stage when he approved it?
Mr. Molefe was the Group Chief Executive at the time.
And what powers did he have in relation to procurement? Because we've learnt about the BADC, the Board Acquisitions and Disposals Committee.
Chair, so we had a delegation of authority with various levels. So the GCE would have had authority to approve transactions up to a certain point. Thereafter, it would need to go to the Board Acquisition and Disposal Committee, and for higher value items, it would need to go to the Board of Transnet.
Chair, may we take a short adjournment, and may I see you in chambers, please?
Yes, no, so how much time do you think? Should we just take the tea break now?
Sure. If we could take the tea break now, please.
Yes. Let's say 15 minutes up to 10 past.
Thank you, Chair.
The tea might not be ready. We'll take the tea break until 10 past 11. Adjourn.
All right.
I can't go. Can you continue?
grateful, Ms. September, that you were here so you can take over. Mr. Pretorius is not well and has had to be released. So, but Ms. September is familiar with the matter and she will take over. Ms. September, are you ready?
Yes, I am, Chair.
Thank you.
Thank you. Mr. van der Westhuizen, before the short adjournment, we were at page 4 of your statement, and in particular, it was placed on record that the evidence that you've recorded from paragraphs 12 to paragraph 17 has in fact already been dealt with by a previous witness, that being Ms. Shala Pillay, who is now Chetty. Is that correct?
That's correct.
Is it also correct that it was in fact Mrs. Chetty, who had in fact approved the award in her acting capacity as General Chief Executive at that particular point in time?
That's correct.
If we can then go to paragraph 18 of your statement, it is understood that T-Systems at the time filed its bid not independently, but instead as a joint venture. Can you please give the Chair details in relation to the constitution of such joint venture?
Sure, Chair. So the bid by T-Systems was a joint bid between themselves, T-Systems, as well as a company called Broadband Infraco, also known as BBI, which was a state-owned company at the time.
And in regard to Broadband Infraco, what were the assertions made that Broadband Infraco could benefit the transaction by pairing up with T-Systems?
Well, Chair, T-Systems didn't own a significant network at the time, so they would need additional infrastructure assets, which is why they partnered, I believe, with Broadband Infraco.
Chair, Broadband Infraco, is in fact an entity which will feature prominently when all the evidence is in fact placed before you. Salim Essa, in particular, was a non-executive board member of Broadband Infraco, and he was appointed as such by then Minister Malusi Gigaba. If we can now turn to page 6 of your statement. Paragraphs 19, 20, and 21, is also evidence that was placed before this commission by Ms. Shala Chetty.
That's correct.
In the context of Ms. Shala Chetty having signed off the memorandum which duly approved the issuance of the letter of intent to award the network services contract to Neotel, was her signature necessary to complete the procurement process at all?
Chair, so at the time, the Board Acquisition and Disposal Committee delegated its authority to the Group Chief Executive to conclude the transaction, which in this specific scenario was Shala Pillay, now Chetty. So yes, it was.
So where was the Group Chief Executive at that time?
Chair, my understanding is that Mr. Molefe was abroad at the time.
So it's then correct to say that her signature in fact completed the procurement process.
That's
in
correct,
this
Chair.
regard?
Yes.
So to put this into context in relation to 2007 MSA agreement, which was due to expire in 2013. It is understood that when Mrs. Chetty, had in fact approved the awarding of the bid, letters of intent and letters of award needed to have been sent out.
That's correct.
What exactly happened once Mrs. Chetty had made that approval to award the network services contract to Neotel?
Chair, so we were quite eager to get the documents back from Charla at the time because our contract expired on 31 October 2013, I think it was the second extension, and any expenditure post that date, we would be out of contract, and in terms of the Public Finance Management Act, it could be irregular expenditure. So Charla sent the mail back to us. I can't recall exactly who, but I remember that I had sight of it with all the signed documents, and I then followed up with procurement, who oversaw and managed the process to confirm that they'll send this to the relevant parties so that we are not out of contract from the next day. I then received a phone call, if I recall, from Mr. Peter, or an email stating that he's been instructed not to issue the documents.
And is that Mr. Gary Peter?
That's correct. That's Mr. Gary Peter.
And he held the position of what at that time?
Gary was the Group Chief Supply Chain Officer at the time.
Thank you. Please proceed.
Sure. And the feedback that he gave me, Chair, is that Mr. Singh requested that he does not issue those documents on request from Mr. Molefe, who's abroad, and he would like to review the documents personally.
So you got this call, and from what you were told by Mr. Gary Peter, Mr. Brian Molefe had given this instruction while still abroad, as you understood the position.
That's correct, Chair.
Okay.
So is it then correct that the proper procurement process was followed up and until the stage of Mrs. Chetty appending her signature to award the contract to Neotel?
Yes.
And it is also then correct, based on your evidence, that pursuant to that process, the letters of intent in alignment with that process were not sent on the instruction of Mr. Brian Molefe?
That's correct.
What then happened during November 2013 following the occurrence of these events?
Chair, we were called to a meeting subsequent to Mr. Molefe's return, and we were called to the 49th floor, which is the floor which his officers were at.
And who was we? Who were we?
Apologies, Chair. So we were myself, Mr. Anoj Singh, Mr. Edward Thomas, who was in supply chain at the time, and the Chief Information Officer, Dr. Mansika Matuane. There could have been others, Chair, but I recall those individuals were at the session.
And if I may, is this the meeting that you referred to that happened in November of 2013?
Yeah.
Paragraph 23 of your statement.
It is.
Thank you.
Chair, we arrived at Mr. Molefe's office, and we, from what I recall, were greeted by his personal assistants to ask us to leave our cell phones at a desk, which I find peculiar because I have met in his office before and I wasn't requested to leave my cell phone at his personal assistant's desk. But regardless, so we all handed it in and we went into his office and we had a meeting. Upon us all sitting down around Mr. Molefe's table, I remember he was quite relaxed, and he, if I recall his words correctly, he said, we can't give this thing to Neotel, there's too much concentration risk. I then...
I'm sorry, before you do that, before you proceed, you have mentioned some of the people whose names you can remember who attended that meeting. Apart from those people, from Mr. Molefe's side, was he alone?
He was alone, Chair.
Okay, thank you. So you said there's too much concentration. We can't give this to
Neotel.
Neotel. Yeah.
Chair, upon that statement, I then inquired, from what I recall, well, exactly who he would like to give it to then, because if you look at the process and the tier report that you've seen that we've recommended, Dimension Data was the second preferred or the second best bidder, and T-Systems and Broadband Infraco was the third bidder. Mr. Molefe was then of the view that the 240 million, which again I believe you've seen, but happy to elaborate on it if I need to, we should include in the process, which would then imply that T-Systems, Broadband Infraco would be the second best bidder, and due to this concentration risk that Mr. Molefe articulated, that the tender should then go to the second best bidder, which in his mind was T-Systems and Broadband Infraco.
What exactly is concentration risk?
Chair, so concentration risk, from my understanding of what Mr. Molefe articulated, was the fact that Transnet was Neotel's largest client, and if something should go wrong with Neotel for whatever reason, that Transnet would be exposed to quite a big risk.
So in other words, did you understand the concern he was expressing as meaning that this tender should be given to somebody else so as to bring in some diversification?
Chair, I understood his concern, but I thought the argument was a logical fallacy. It was irrelevant.
Yes. Okay.
The reason I state that, Chair, is because I think, like Advocate Pretorius took us through earlier, the data center that Transnet used was outsourced to T-Systems. So by giving T-Systems the data center, and now you bundle your network with that, in my mind would increase the concentration risk, not mitigate the risk. So that's why I didn't quite understand that, and I provided that feedback to Mr. Molefe.
Or you expressed your view.
Absolutely, Chair.
And what was his response?
He didn't respond, Chair. He looked up, and I could note that his polite, relaxed demeanor was starting to change. He then proceeded to his second point, Chair, which was...
Sorry, let me get that last bit. Did you say he had been polite to you, but that seemed to change?
It was very informal and relaxed when we started the meeting, Chair.
Yes.
And after I now
Expressed a
objected,
different view.
I could see that he was becoming less relaxed, so to speak.
Yes, okay, all right, thank you.
He then mentioned to us that he received a letter from, I think it was Nexus, which was one of the Neotel EE subsidiaries or affiliates, and that they expressed a view that Neotel was busy diluting their shareholding, and they were particularly concerned about this. I can't recall that I've seen that letter or heard anything about it at the time, so again I articulated that it may or may not be a real issue, but I suggest that we then investigate that issue and at least give Neotel the opportunity to respond, should it be a real risk, and to pose their side of the story, Chair. Again, Mr. Molefe did not take kind to the objections. He again did not respond from what I recall, and he just looked up at me with a glare in his eyes, which made me realize at that point, if I continue with this objections, it was not going to involve me, Chair. So at that point...
So you got the impression that he was not, to say the least, happy with these views you kept on expressing?
That's my view, Chair.
Okay.
So upon that realization, I decided to get back in my box, so to speak, and not object to any further items. Mr. Molefe did then raise a couple of other items from what I recall, and it's all captured in that memorandum around information security and CCTV issues that we experienced at the time. That is the crux of that meeting, Chair.
What about the other people who were in the room? Did they express any views? Did anybody support the views you expressed that you have articulated now?
Chair, I can't recall that anyone had the same level of objection that I had. They were reasonably quiet from what I can recall. So I did feel a bit isolated in the session.
Yes. And in respect of other issues other than those on which you expressed views, did other people in the room express any views either in support of whatever Mr. Brymer was saying or against?
Chair, I can't recall that they either disputed or objected nor support Mr. Molefe.
Okay, all right, thank you.
In summary then, you took issue with, you raised objection rather, to the three main reasons that Mr. Molefe advanced to not award the contract to Neotel.
That's correct.
The first,
I'm sorry, maybe, I don't know. It's up to you to answer yes or no, or in whatever way. I'm not sure whether you were objecting as opposed to simply expressing your own view, which happened to be different from Mr. Brian Molefe's view. There's a distinction between objecting and expressing a different view.
Yeah, Chair, so I'm not going to pretend to exactly know what the difference is, but I definitely expressed a view that was different from Mr. Molefe's.
Okay. I mean, if you object, it's much more, it's like, I think it's much more stronger. Whereas if you can express a different view without saying you are objecting, particularly if the person to whom you are talking maybe has the final authority to decide one way or another. You might say, well, here is my view. What you make of it, what you do with it is your own decision, but this is my view. Another option, another approach is to say, I do object, irrespective of what you might say, I am objecting. So I'm just mentioning that so that you appreciate that there can be a difference. Sometimes the difference might not be important, but...
Chair, so based on that explanation, I expressed my view because Mr. Molefe had the final decision, so whether I objected or not was not going to carry any weight. So,
okay, thank you.
thank you, Chair. In regard to the three main reasons then, the one reason which Mr. Molefe had advanced concerned the 248 million discount that was offered by T-Systems. Can you just unpack this particular discount for the benefit of the Commission, and in particular, the timing of considering this discount?
sure. Chair, so I was present in most, if not all, the RFP sessions, and I pretty much led all of them. And I recall during the process that I made it extremely clear that our best and final offer was on the Thursday before a particular Thursday, and we can check the dates, Chair. So I recall mentioning it over and over and over and checking that all the bidders understood it, which I'm sure they did. Post receiving all the pricing back from the bidders, there were some included mobilization fee and some did not. So we just wanted to clarify that.
Can you just clarify what is mobilization fee, please?
Yes, so Chair, it was referred to as mobilization or transition fees. So as part of the 2007 Master Services Agreement, there were certain service level agreements or SLAs linked to that agreement. Subsequently, the world has changed and Transit wanted stricter service level agreements. To give you an example, we wanted redundancy so that if a network line goes down, that there is another line and the port isn't down from a network perspective, things like that. So in order for Neotel to transition, or wherever the bidder would have been, from Neotel to transition to that level of service, there would have to be an investment, additional fiber lines, additional network switches and routers and those kind of things. So that's what I refer to as the transition cost, or yeah.
So to not oversimplify mobilization fee, it's essentially the cost of handover from one service provider to another.
And increased service levels should the current incumbent Neotel remain the service provider.
Thank you.
Yes.
Coming back to the discount of 248 million, was it an appropriate time in the process for this discount to be considered a consideration for the award of the bid?
Absolutely not, in my opinion, Chair. Like I said, I made it very clear that the best and final offers had to be submitted on a certain date, which they were. Subsequently, there was a clarification session with T-Systems and Broadband Infraco. There was it was multiple people present at this meeting. There was a gentleman, however, that represented Broadband Infraco. I can't recall his name, though. It wasn't Mr. Essa, that I know as a fact. He then indicated to us that due to the short timeline, they couldn't meet with their minister or their shareholder, which is the DPE shareholder, in time, and they managed to meet with the shareholder over the weekend, and the shareholder indicated that they would be willing to invest an additional amount of 248 million rand into this process. I then clarified and said, well, okay, so what does that mean? Does that mean that we can reduce your price with 248 million? Absolutely, they said. But it was post the best and final offer. So if we even should have considered including that, which we did not, my view is that we should have at least given the other bidders a similar platform to give us a view if they were happy with their pricing, because effectively now there's a second best and final offer, but that opportunity, from what I recall, was only afforded to T-Systems and Broadband Infraco.
And the other bidders were not afforded such opportunity?
Not that I can recall, Chair, no.
Did Mr. Brian Molefe have the authority to change the process that was being followed?
Chair, so I think this enjoyed some attention last week from a few legal minds, I think including Mr. Volmink. In the memorandum that we've attached, it does appear that there are certain leniencies and that potentially Mr. Molefe could disagree based on risk, but there was a certain process to be followed.
And what was that process, please?
Chair, from what I recall from the documents, and we can go there if we need to, the GCE had to revert back to the committee that recommended the bidder to resubmit and reassess. Like I said, we had a meeting, but in my mind that was certainly not a consultation nor a request for us to go back and reconsider. It was pretty much an instruction. So I don't believe, in my opinion, that process was followed.
Do you understand?
Well, I'm sorry. In relation to that aspect and that part of the, I think, manual, the witness who gave evidence, I think, on Friday, I asked her whether that procedure, in terms of which the decision maker is supposed to go back to, I think, what are called recommending officials or officers. I asked her whether that procedure applies before a decision is made. So in other words, when there are only recommendations from a lower structure, before the person who has the power to make the decision makes the decision, if he or she thinks, I see this recommendation that I should award this tender to A, but I actually think it should go to B or C, or I don't think it should be awarded to A, whether that's the process, that's when this procedure applies, or whether it does apply when a decision has already been taken. Now, when I asked her that question, she said, if I recall correctly, it applies before a decision is taken. But much earlier in her evidence, I had also asked her the question whether, where a decision has already been taken, the person who took the decision or the person occupying that position can later on seek to change it. And my understanding is that she said, yes, in certain circumstances it could be done. And she, I think, said, if, for example, something has arisen that was not foreseen or something like that. So that was, as I recall, the sum total of evidence on this aspect. So I don't know what your own understanding is.
Chair, so I would concur with Mrs. Chetty's view. So the question then is, was this, so she approved the process, I think, like we've confirmed before. To what extent Mr. Molefe shared that view because the documents were not distributed, I don't know. But nothing in my mind happened post the approval from Mrs. Chetty to the turnaround, if you will, from Mr. Molefe. I mean, if Neotel went into liquidation or something like that, I could understand that something material has happened that will impact their ability to deliver the services. And like I said, nothing to that happened in my mind. So number one, he probably couldn't have, or nothing like that occurred. And if something did occur, again, he would have to revert back to the committee that you refer to, or the recommending officers, which again, in my mind, did not happen.
So would you say that there is a procedure in terms of which the decision maker, if may, go back to the recommending committee or of officials where he or she thinks he or she doesn't agree with their recommendation, but that there is also provision, or there's also provision for an award to be changed if there are certain circumstances such as the one you have cited, namely liquidation and so on?
Chair, in my opinion, yes, there would be a procedure like that for
Yeah.
examples like I've noted.
For both situations.
So-
In other words, both procedures exist as far as you understood the position, namely the procedure before a decision is taken. If the decision maker thinks he or she doesn't agree with the recommendation from the recommending officials, he or she is required to go back to them and raise his or her concerns before making the decision. But apart from that situation too, if a decision has been made and certain circumstances arise that were not foreseen, the decision maker can relook at the whole thing.
Yes, Chair.
That's what you say. Okay, thank you.
In that regard, then, can I take you to exhibit bundle BB7 and B?
Is it B file?
It's the second one. And page 331.
The divider is number what?
It is,
I think it's K2, Chair.
it's annexure K2, thank you.
K2, thank you.
K2, and it begins on page 331.
Oh, okay, thank you. Yes.
Do you recognize this? Do you recognize this document?
I do, Chair.
For the record, it is a memorandum that is from Brian Molefe, Group CE, to Anoj Singh, Group Chief Financial Officer, Matsika Matuane, Chief Information Officer, and Gary Peter, Group Chief Supply Chain Officer. It is dated 20 November 2013, and the subject relates to the provision of network services as it's amplified in the title. How are you aware of this document? What is your knowledge of this, of the compilation of this document?
So, Chair, I compiled most of this document post the session with Mr. Molefe.
And when did you compile this document?
Chair, I can't recall exactly, but I think I compiled it shortly after, pretty much the same day from what I recall,
The same day as?
as the meeting from what I recall.
And on whose instruction did you prepare this document?
So post the meeting with Mr. Molefe, Mr. Singh and I had a brief conversation, and he instructed me to compile this memorandum with the relevant input from supply chain sourcing and or group supply chain and so forth.
Let's go back to that meeting and round off, because I don't think we did round off. What was the outcome of that meeting in Mr. Brian Molefe's office?
So, Chair, the outcome was that he was of the view that we need to award this tender to T-Systems and Broadband Infograph.
And other than the different views that you had expressed, you can't recall that anybody expressed any view different from his view on any of the on that issue?
Not to my recollection, Chair.
Yes. Okay. All right. Thank you. You may proceed, Ms. September.
Thank you. Based on the objections, or rather, what is the crux of this memorandum in relation to the award of the tender?
So, Chair, effectively what this memorandum does is it reverses the decision or the recommendation from the recommending officers to award the business to Neotel, and it takes into account firstly the 248 million rand, and based on certain perceived risks by Mr. Molefe, it awards the tender to T-Systems, or a letter of intent.
More accurately stated on page 337 of this document, Mr. Brian Molefe seeks approval for what you've just given evidence about. Is that correct?
So I don't think Mr. Molefe wanted approval. He was giving us an instruction, yes.
Sorry, my mistake. Apologies. If we could then just go back to page 331. You've mentioned that you were integral in the preparation of this document. If you had such strong views about why the recommendation of Mr. Brian Molefe was...
Well, I'm just thinking whether he said anything about those views being strong.
Okay. Let me rephrase.
Well, it may be that they were strong. I'm just wanting to...
Let me help. I was in violent disagreement with what Mr. Molefe said.
Sorry?
I said just to help, I was in violent disagreement with what Mr. Molefe said.
Oh, okay. All right. Yeah.
Well, then in violent disagreement with what Mr. Molefe said.
That's very strong. Yeah, so no, that's fine. I just wanted to make sure that we don't have a situation where the record might reflect something that he might not have intended. But if that's a correct description of his views, how he expressed them, that's okay.
Thank you for the correction, Chair. Mr. Van der Wester is in violent disagreement of Mr. Molefe's views. How and why would you author a document that is contrary to views that you hold so strong?
Chair, so my views at the time were if I do not put this document or compile or author this document, that my career at Transit would be short-lived, and in no way was I going to sign this document. Just to add to my emotions at the time, I recall distributing or updating and distributing my CV from what I recall on that same day, because I just saw affidavit written all over this, to be honest. So I don't think that I had much of a choice, and I thought that my employment would be ended and someone else would have compiled the memo.
Let me put this, and this is not to say change what you say, I just want you to appreciate and be able to say this is the position or that is the position. There are two possibilities. The one possibility is that if what you did at the meeting was you regarded it as something necessary or your duty to express your views, to say, these are my views, but I know that it's not necessarily my views that need to prevail, but these are my views. If you get persuaded that is now Mr. Molefe, If you are persuaded and you agree with me, then that's fine. But if you don't agree and you insist that this be done, I will have expressed my view, and if I'm asked or instructed to have a role in carrying out what you, as the person who has the power to decide, want to be done, I will do that. That doesn't change that I don't agree, but I will do it because you are the one who has to decide. That's one way. Another way is to say, well, if I had it my way, I wouldn't even compile it for him, but I did because I felt that I would be risking my job. So the one situation is where you did it because you felt that you didn't have a choice. Another way would be where you did it not necessarily because you didn't feel you had a choice, but because you appreciated that he's the one who must make a decision, right or wrong, and yours is to express your views and let him decide.
So Chair, ultimately he was the decision maker in this regard. I expressed my views to him and I still disagreed with it, but like you said, ultimately he had the delegation to make the decision. He was appointed in that role as my superior by the Department of Public Enterprises, and I had to respect that, and therefore I drafted the document.
At paragraph 28 of your statement, you, and I will quote, you say that your objections would be tantamount to professional suicide. In follow to the question raised to you by the chair, what informed your decision, or your view rather, that this was the ultimate outcome of professional suicide, to quote you, if you did not do what you were told to do?
Chair, like I said in that meeting, Mr. Molefe's relaxed demeanor changed very quickly, and I could see in his eye, and maybe I misread the situation. I doubt it though, but I could see clearly that if I say another word, security is going to escort me out the building today. That was my view.
Okay. If we can then go back to this particular memorandum that you assisted in preparing. Paragraphs 4 and further deals with the procurement process that is to be followed in relation.
Maybe we might be leaving something hanging that should be dealt with.
No problem.
Maybe the part of your statement that Ms. September just referred to maybe puts your situation more in line with fearing losing your job if you didn't cooperate than the position that you had expressed your view and you left it to him to decide, and not necessarily that you are fearing losing your job. What do you say?
Chair, sir, I firmly believe that if I did not draft this memorandum, that I would have been sidelined and let go over time.
Yes.
That's where the professional suicide came from.
That you would have been victimized in one way or another.
Absolutely.
Okay, all right.
So from paragraph 4 on, the procurement process is in fact dealt with, and in particular from paragraph 5, the role of the acquisition council is documented. If I could ask you to go to page 333 of the same bundle, at subparagraph in italics 20.5, which is titled Disagreement Regarding Award of Business, and I shall read. Paragraph 20.5.1 says, should a dispute arise between the recommending officers and the AC, being the Acquisitions Council, regarding a submission after the AC has referred the matter back to the recommending officer for remotivation, the matter must be escalated to the entity's CEO for a final decision. Do you have any comment in relation to the application of this process to the circumstances that you've explained now relating to Mr. Molefe recommending that the award be given to Neotel?
So, Chair, I think as we've just sort of discussed, if...
Sorry, to T-Systems.
Yes. So as we discussed, if one could argue that something catastrophic or material happened and therefore Mr. Molefe needs to overturn the decision by Ms. Belay, my reading of this would be that he needs to refer the matter back to the recommending officers for remotivation. Not that I'm a lawyer, but that's my reading of it, and that did not happen. Like I said, we did not have a consultation, we had an instruction meeting.
So there was no remotivation?
No.
There was no referral back to the Acquisitions Council?
No, to the recommending officers, which were the signatories to the tier report.
Thank you.
That clause 20.5, 20.5.1 talks about a situation where there is a dispute that has arisen between the recommending officers and the AC regarding a submission after the AC has referred the matter back to the recommending officer for remotivation. Am I right to think that that is a situation, what that clause deals with is a situation where a recommending committee or official sends a recommendation to me, and I'm the one who must make a decision. And they say, they recommend that the tender be given to A. And I look at their motivation for that, and I look at everything that I'm supposed to look at, and I don't agree. That then I must send it back to them and say, what about this, what about that, what about that? Because it seems to me that the tender should be given to B. And then I give them an opportunity to deal with my concerns. And then if they revert to me after looking at the issues I've raised with them, and they still stick to their recommendation, and I still stick to the view that they are wrong, that is when this clause applies. Is that in line with your understanding?
That's in line with my understanding, Chair, yes.
Yes. And then with regard to, okay, before I proceed, because then in that situation, a dispute has arisen between the one who must make the decision and the ones who made a recommendation as to who should get the award. Then in that event, the power to make the final decision goes to the entity CEO, according to this. Is that right?
That's
your
my understanding of it
well.
as well, Chair. So where I'm differing slightly is that the matter must be referred back to
Yes.
the recommending officers.
Yes.
And in my mind, that did not happen. Like I said, we had a meeting where Mr. Molefe expressed his concerns. I raised or gave him my views, but at no point were we asked to remotivate. So I suppose it depends on your interpretation of whether that meeting constitutes the remotivation
Yes.
or not.
Well, I'm going to go to 20.5.2 just now, but I think you are saying that the scenario that I've put to you falls under 20.5.1.
In my understanding,
That's
Chair,
your
yes.
understanding. So in that event, it would be this CEO of the entity who makes a final decision, and not the person who otherwise would have made the decision because there is disagreement.
That's correct.
Now, 20.5.2 says where the recommendation of the evaluation team, I see that now they are not talking about a recommending officer, where the recommendation of the evaluation team conflicts with the opinion of the end user, the matter must be referred to the AC for a ruling. So that is a different stage, a different scenario, is that right?
That's my understanding, Chair. So if you look at 20.5.2, to try and explain it, my understanding of this is that if the evaluation team had a recommendation and group ICT in the scenario, or the technology team had a different view. So let's say they came up with a scenario and said it should be T-Systems, and we said, guys, the T-Systems can't, for whatever reason, deliver it. So prior to it going to the final decision maker, we already have a difference of opinion. That, in my mind, is 20.5.2 would apply to that scenario.
Yes, yes.
Where, in this case, there wasn't a difference between what the recommending officers and business or the end user were recommending. We were all in agreement that, based on the process followed, including all the technicalities, Neotel was the preferred bidder.
But we agree that the scenarios are different for the two
I agree, Chair.
clauses, yeah.
Yes.
And in regard to clause 20.5.1, that does not seem to have been applicable because a decision had already been taken by Ms. Chetty in this case. So by the time Mr. Brian Molefe got involved, a decision had already been taken. So clause 20.5.1 doesn't appear to have been applicable. Is that your understanding as well?
I would concur with that view, Chair,
Yes.
unless something catastrophic or material happened where we
Yes.
needed to relook at the situation, and like I said, in my view, nothing did.
Yes, but I think that probably is dealt with by another provision.
Sure, okay.
And then it also, 20.5.2 was also not applicable in this case.
I agree.
Yeah, okay, all right, thank you. So as far as you know, there was nothing in the policies of Transnet which justified that Mr. Molefe should revisit a decision that had already been taken by somebody who had the power to make that decision when he was not around.
I'm not aware of any such.
Yes, okay.
Thank you, Chair. If we could then turn to page 335 of the same document. Is it correct that paragraph 7 documents your specific concerns in relation to the recommendation that was advanced to you by Mr. Brian Molefe?
So, Chair, these highlights the concerns raised by Mr. Molefe in the session.
Okay, and just for the record then, it would read that I have the following specific concerns with your recommendation and responses to me, including the responses to me in the various meetings held with the recommending officers for remotivation, which is discussed further in this document. A, counterparty risk and alienation of state assets. B, concentration risk as Transnet is Neotel's largest client. C, BBEE partners, which is your broad-based black economic empowerment partners. D, information security incident. And E, CCTV camera exposures. This paragraph talks specifically to a remotivation. Are you aware of any remotivation that took place?
No, I'm not, Chair.
At the meeting in Mr. Brian Molefe's office, at the meeting that you talked about, where you expressed certain views, when he said that he thought that the 240 million rand should be taken into account, you did express your view about that as well, and did tell him how this issue had been dealt with before.
Chair, I can't recall if I specifically mentioned it in the meeting, but the TARE report that we signed was very clear on the 248 million and why we think we should and cannot include it in the tender price.
Is it possible that he raised the issue of the 240 million rand after you had expressed your views, I think, on two aspects, and you got the impression that he was not very receptive to different views? Could it be that he raised it after that, and you felt, look, I'm not going to be saying anything now?
Chair, I think it was raised
At the
sort of
beginning.
at the beginning. The reason I'm
Yes.
saying that is I would not have counter-argued or expressed a view that it increases the concentration risk if we gave the tender to T-Systems. If we gave it to Dimension Data, as an example, who was the second best bidder, if for whatever reason you felt you wanted to exclude Neotel, that would not necessarily increase. It would probably mitigate the concentration risk to some extent because they were a larger organization with far more clients. So we had to have discussed the 248 to get from bidder 1 to bidder 3, which is now bidder 2.
Okay, thank you.
Throughout the communication exchanged with Mr. Brian Molefe and the memorandum that you prepared, which was eventually signed off, what was Anuj Singh's views on the change of decision?
Chair, I can't recall if Mr. Singh had a specific view or whether he supported or was in disagreement with the view. It was pretty much just we need to get it done and therefore the instruction on the memorandum. But I can't recall that Mr. Singh was either in disagreement or supportive of the overturning, if you will, of the recommendation.
Okay. Who was ultimately responsible for the overall procurement of this particular contract?
So, Chair, at that stage, if I recall correctly, the group's chief supply chain officer was Gary Peter, but that function reported into the group chief financial officer, being Anuj Singh at the time. So, in my mind, Mr. Singh would have been overall responsible for procurement.
And absent Mr. Singh raising any contrary views to the position taken by Mr. Brian Molefe, is there any reason for you to believe that he didn't agree with the approach adopted by Mr. Brian Molefe?
Yeah, Chair, like I said, I can't recall if he had any objections, but in the absence of that, like you state, advocate, it probably means that he was likely supportive.
And then lastly, based on the evidence that you've given in relation to this change of decision, is it to be understood that the change of decision to grant the award to T-Systems was independently done by Mr. Brian Molefe?
Is in my opinion, Chair.
Are you aware as to whether or not...
Sorry, what was the answer?
I said, in my opinion, yes, Chair, it was Mr. Molefe unilaterally made this decision.
Okay, well, she said independently, and I'm not sure what you have in mind, Ms. September.
The witness is actually, I just answered.
So she asked whether you thought that Mr. Molefe made the decision independently. Are you saying yes, he made it independently? Whatever.
So,
if you are not sure what that means,
sure.
you can ask
So,
for clarification.
maybe just help me with what you mean with independently in this scenario.
Was it a unilateral decision by Mr. Brian Molefe to change the decision from awarding the tender to Neotel, from Neotel to T-Systems?
In my opinion, yes, it was.
I guess unilateral in the sense that those who had been involved in working on the matter were, as far as you are concerned, were certainly not, or did not agree to it.
Absolutely.
But are you able to say that he did not consult them? You know, unilaterally can mean without consulting.
Chair,
Can mean without agreement from somebody else, just on your own.
Chair, so the only session that I'm aware of and that I was present at was that particular meeting where he raised these views.
Yeah.
We expressed a different view, and the decision was made pretty much at that meeting, from what I understood. I don't believe there were other consultations, but...
Yeah. But you would also not know everyone he may have talked to about
Correct.
it. Yeah.
That's correct, Chair.
Thank you. Who had to manage this contract going forward?
I was.
So were you the business owner, if that's correctly stated?
So ultimately, the Group Chief Information Officer would be the business owner, but I was the representative in this scenario, because obviously she couldn't attend all meetings, so it would have been me indirectly, yes. And also I was the head of vendor management for Transnet ICT, so this would have been one contract that, yes, the team would have managed.
And despite the views that you raised, your views were ignored?
I believe so, Chair, yes.
So the decision is taken by Mr. Molefe.
Ms. September, I don't know whether you intend ignored.
Okay.
And I'm saying this just so that the witness, when he agrees or doesn't agree, he should appreciate what he's agreeing to or not agreeing to. Some people say somebody's views have been ignored when they actually mean that those views were not agreed to. But their views might not have been agreed to, but they may have been taken into account, and that means they were not ignored. You know, you can express your views, you can make your submissions. The fact that I don't agree with your submissions doesn't mean I've ignored them. I may take into account, but don't agree with them, and therefore I go ahead and make my own decision. But I have taken them into account, so therefore I've not ignored them. So I'm just saying I'm not sure whether you meant ignored or what you meant.
Let me rephrase.
Because Mr. Molefe may have taken it into account, taken the views into account, but just didn't agree with them.
We rephrase then. Mr. Van der Westhuizen, you were the business owner. Is that correct?
Yes.
It's also correct that you've given evidence that you were the one that was responsible to manage this contract going forward.
Yes.
You were then important, and particularly your views were important in the process of the award of the tender.
I believe so.
Despite the views that you raised, which were important to the process, it was not considered persuasive enough to alter the decision that had been taken to re-award the tender from Neotel to T-Systems.
Correct.
That's much better. Yeah. The decision was made to change Ms. Chetty's decision, notwithstanding the views you had expressed.
That's correct, Chair.
Yeah.
What then happened once the decision was changed by Mr. Molefe? What was the process that was then followed?
Chair, so post that decision and the relevant documents being signed, T-Systems would have received a letter of intent, and all the other bidders would have received a letter of regret. What would then have pursued is that we would have started negotiations with T-Systems in order to conclude a 3 to 5 year master services agreement as per the RFP process.
Did Neotel raise any concerns with Transnet following receipt of a letter of regret?
Chair, they did. I can recall that Mr. Sunil Joshi, who was the CEO or managing director at the time of Neotel, wrote to us formally to the GCE, Mr. Brian Molefe, requiring or requesting some clarity on the reasons we posed in the letter of regret, which stated, from what I recall, business risk was the reason why it was not awarded to Neotel. And Mr. Joshi then also asked or stated that he and the team couldn't recall that that was a pre-qualification criteria or mentioned anywhere in the request for proposals.
We are now at page 10 of your statement, paragraph 35. If I could ask you to go to the bundle BB7.
Sorry, if you could just say the page number again, please.
So if you could go to page 411 of the second bundle, which is exhibit BB7B.
Oh, I thought you said we were going back to the statement.
Oh, no,
So did
sorry.
I.
Oh, is that what you had also?
Yes, Chair.
Yeah,
No,
I
I'm
think she said
confusing
page
myself.
10. Okay, so what page must we go to now?
Page 411.
Okay. Yes.
Do you recognize this document, Mr. van der Westhuizen?
I do. I do,
What-
Chair.
Please identify it.
Chair, so this appears to be the response to Mr. Sunil Joshi based on the letter that he wrote to Transnet.
And if I can take you to page 413, which concludes at paragraph 13, it reads, due to the above business risk considerations, Transnet has made a decision not to award a 3-year network contract to Neotel. This network is the heart of Transnet business, and awarding the business to Neotel will expose Transnet to unnecessary risk. And this is the letter that you had referred to earlier.
Yes, Chair, I just don't know if this was the final letter that we eventually sent. There could have been slight changes to it because I see this is the unsigned one, but yes, I think this was the crux of it.
Thank you for that clarity. How would you describe the relationship between Transnet and Neotel following the sending of the letter of regret to Neotel?
Chair, to be blunt, the relationship was extremely strained after that because I do think, taking into consideration the history that Neotel took over Transtel, a lot of the employees through a Section 197 moved to Transtel. A lot of those individuals still have had contacts with a lot of people at Transnet. So I have no doubt, to be honest, that some of the information must have gotten out regarding this turnaround of the tender, and I think they were flabbergasted that they lost this. They couldn't lose it. They're the current incumbent. They can provide the services, likely the cheapest, and quite frankly, no one else can without them. So it was the relationship was extremely strained post that letter of regret.
And what were your concerns around this now strained relationship with Neotel in view of the 2007 MSA?
Chair, well, of particular concern was a number of concerns. One was service delivery, because they don't really have an incentive to meet the service level agreements at that point. I don't think the service credits were adequate to mitigate that risk. The second concern that I had is pricing. So prior to us concluding the process, we signed an extension with Neotel, and I think it was a 2 or 3 month extension. We could check from 31 October, so 1 November to 31 December. And in that extension, we managed to get Neotel to commit that should there be further extensions, that the price would reduce. The price at that point, Chair, if memory serves, was 42.3 million rand a month. Post this letter of regret that was issued to Neotel, they wrote back to us stating that the fee going forward will be 58 million rand a month. So it increased with 15, 16 odd million rand immediately. We then met with Neotel and managed to, convince them that that is madness, and we eventually settled with no negotiating power on 50 million. So the price went from 42.3, if I recall correctly, to 50 million within a month for the remainder of the contract.
I get the impression that you didn't think that there was justification for this increase.
Absolutely not, Chair. It was exactly the same services that they were providing. They were cross because they lost this tender.
Yes. And Transnet didn't have much of a choice as you saw the position. In other words, you didn't think Transnet could say, well, we're not paying 1 cent more than what we have been paying you.
Chair, we could. The risk is that they switch off our network.
Yes,
And
that's what I'm saying,
yes,
that
yes.
you run a risk of
Yeah.
something much more.
And
So
Chair,
you were in a corner.
we were absolutely in a corner, Chair. And I think just for context, Transnet at that point in time, if I'm not mistaken, was a billion rand a week organization. So if you switch off the network, your rails or your trains, your ports are heavily impacted, as well as safety and a number of other things. So it's really not a position you wanted to be in. So we had no negotiating power.
So in a way, even if they had not come down from 58 million, you might have had to just pay. Is that right? Is that how bad the situation was?
That's how bad it
how
was.
How vulnerable Transnet?
Absolutely, Chair. And we'll talk
Yeah.
about it a little bit later when we get to the asset buyback as well.
Yes, okay, thank you. You are just lucky that they were able to come down about half
Yeah.
of the increase they had demanded.
I think the team still had good relationships at a lower level, Chair, so I think we managed to,
Yes.
to negotiate it out.
Okay.
Just to put it into context, can you give some more detail as to what exactly it would mean for Transnet's operations if Neotel decided to pull the plug?
Chair, so like I tried to explain, the ports would be heavily impacted. From what I recall, Transit Port Terminals had a system called Navis, which was heavily reliant on a low latency network, from what I recall. The trains would be, the communication systems, although Transit Freight Rail still had a sort of a separate system, the trail operations would have been heavily impacted as well, from what I understood from the operations and more technical people. So it would have been catastrophic, yeah, so.
So Transnet would not have been able to deliver the service that it does if Neotel pulled the plug?
Absolutely not.
But this vulnerable position in which Transnet found itself now, at that time, when it agreed to effecting an increase and putting the amount at 50 million rand or so per month. It was per month.
I beg your pardon, Chair, it was?
The increase of the price, it went up to 50 million.
That's right.
And that was per month?
That's correct.
Yes. That was a result really in the final analysis to Transnet having sold its network to Neotel.
That was a result of that decision, Chair, yes.
It put itself in a very vulnerable position.
That's correct.
Yeah, okay.
Did you raise your concerns with the current state of play? Or the then current state of play in relation to the Neotel having this hold over Transnet in context of the MSA coming to an end?
Chair, I think even before we went to market, the ICT management team raised our concerns that we were in an impossible negotiating position, and that's why we recommended in one of our first recommendations that we potentially not go to market, but we extend this contract with Neotel, because we were of the view that that would give us the ability to potentially buy back these assets should we commit more revenue to them over a period of time. I think the board didn't necessarily agree with that position, and then that's why we went to market. And I think this turnaround of the decision then again exacerbated that problem, because now you had your Neotel's back against the wall and they were yeah, angry.
At page 11 of your statement, paragraph 38, You were informed that it was pursuant to discussions between Anuj Singh and Sunil Joshi, who's Neotel CEO at the time. Neotel agreed to continue with its services. Is that correct?
That's correct, Chair. So upon the, if I recall, the timing here was we were informed at this point that we were not going to issue the letter of intent to T-Systems and the letter, I beg your pardon, the letter of intent to Neotel and all the letters of regret. So this was really the, no, let me just pause for a second. This was when procurement informed me that they were not issuing those letters as approved by Mrs. Chetty. And like I said, that was the 31st of October 2013, if memory serves, which meant that from tomorrow, we are out of contract. Any expenditure would potentially be irregular, and we have a proper service delivery risk. I then raised it with Mr. Peter and Singh after he communicated to me that Mr. Molefe would like to review the documents upon his return, to which Mr. Singh replied saying that he's personally discussed it with Mr. Joshi and that Neotel will continue delivering service to Transnet.
Thank you. At paragraph 9, you document a series of events. Paragraph 39, page 11 of your statement. Can you take the Chair through these particular series of events which occurred during December 2013?
Sure, Advocate. Chair, so what occurred is that we provided Neotel with a 12-month extension. I think I mentioned and covered the price increase from 42.3 to 58 and then negotiated down to 50 million rand. And in that acceptance letter from Neotel, they indicated that there was quite a lot of equipment that was end of life, and should that equipment fail, they cannot guarantee our service level agreements anymore. So attached to correspondence, they requested that we pretty much procure, if I recall, 69 million rand worth of Cisco equipment then and there in order for them to accept the 12-month extension, which was issued in December.
So is it correctly understood that Neotel then had two holds over Transnet? On the one, it was in relation to the MSA that was about to reach an end, in terms of which they also then held ownership of assets that was coming to an end, but they could not then guarantee the service unless you had negotiated terms and conditions in relation to that.
That's factual, Chair, and you could argue that they were in a strong legal position should they wanted to take us to court over this decision as well.
You mentioned Cisco equipment. Is this may then be an appropriate time for you to unpack the involvement of Cisco?
Sure.
And its engagements with Transnet for the new equipment?
Yeah, so Transnet network, much more technical person or people will explain to you that you introduce unnecessary risk into your network if you have multiple OEM providers due to compatibility. So Cisco was the preferred provider for Transnet on the Transnet network, but like we mentioned before, any Cisco equipment had to be procured via Neotel. And I think we did also touch on it, but due to the fact that we've overturned, Mr. Molefe has overturned the tender from Neotel to Transnet, to T-Systems, that meant that we had to pull the transition. Well, we were going through a transition now, and we had to try and meet the timeline. And we then had a meeting with all the parties, being Cisco, T-Systems, Neotel, and Transnet management, and said, well, okay, so we've got to pull the trigger on this transition. How do we go about doing it? Neotel then raised with us that apart from this equipment that we procured, the 69 odd million, and we can just check the value, that we procured as part of that 12-month extension, a lot of other equipment in the ports or in the campuses were also reaching end of life and support. And that's why we decided to acquire that equipment through Neotel, but again, like we mentioned earlier, that equipment would be owned by Transnet, because our concerns were the campuses and all of this equipment was in the campuses.
But is it correct that there were 2 Cisco equipment purchases?
That's correct.
The one during 2013 and the one during 2014?
Yes, it's correct.
And the one you speak of now is which one?
Well, I actually spoke of both. So the 2013 one was an invoice attached to the 12-month extension in which Neotel had a number of terms, including the 50 million rand monthly fee, and they also accepted the outcome of the tender, which they signed. Linked to that was an invoice saying, please sign place the following order with us in order for us to guarantee your service levels. That was the first purchase. Subsequent to that, when we started negotiating with T-Systems, we realized this transition was a problem from a timing perspective, and they then informed us that there is significant other equipment that we need to replace in a period of time. Due to the transition and the ownership discussion, we wanted to pull that forward and decided to buy it pretty much then and there.
Okay. We'll unpack the Cisco transaction a bit later as it's set out in your statement. Is it correct that Neotel finally accepted the outcome of the tender process and the award of the tender to T-Systems?
It's correct, in the same letter that I was just referring to.
If we could now look at page 12 of your statement. Chair, paragraphs 41 to 44 on page 13 is evidence that has already been placed before this commission by Mr. Volmink. It talks specifically to the reversal of the decision to award the tender to T-Systems. And in view of this evidence already being placed before the commission, we do not intend to deal with much detail in relation to it.
Yes, no, that's fine. The part which I think wasn't said before, which may have some significance in the context of Mr. Singh's role or alleged role, is that in paragraph 41, it is said that if Mr. van der Westhuizen remembers well, Mr. Singh did request that an opinion be obtained on the process and reversal of the award by Mr. Mulofe from senior counsel. I think I did hear that a legal opinion was obtained, but I don't remember that I had that initiative may have come from Mr. Singh.
No problem, Chair. To
Thank
you,
you.
Mr. Westhuizen.
But I take note that you say as far as you recall.
That's correct, Chair.
Yeah.
My recollection, I think,
Yeah.
I can't recall if it was an email or discussion, but I seem to recall that Mr. Singh requested
Yeah.
that we get the opinion.
Okay, all right.
In paragraph 45, you address a resignation that you submit to Transnet on the 30th of September 2014. Can you please extrapolate the events leading up to this resignation and the resignation itself?
Sure. Chair, I think like I mentioned before, post that meeting, I decided to put my CV in the market, so to speak. I was then approached by a company in South Africa and went through multiple interviews, etc., and they offered me employment, if I recall, somewhere in September. So I then formally resigned from Transnet on 30 September 2014. Subsequent to, and maybe just some context as well, is during that period there was quite a lot of Transnet ICT resources of the management team that resigned. I think there were 3 of us in a matter of a 2 weeks span. And the one crucial one was Mr. Yusuf Lunat, who was our head of infrastructure, and he was very involved in the technical stream of this negotiations. I think Mr. Singh and Dr. Matuani then had, I don't know if they had a conversation, but we had a conversation whether I would be willing to stay on at Transnet until the end of the year and see this contract through. I then engaged with my new employer, who didn't have a particular problem. My concern, however, was that I was going to earn more at my new employer, and the remuneration structure was also much better. So I then indicated to Dr. Matuane and Mr. Singh that I would be willing. I thought it was just fair, to be honest, that we were 3 months from concluding this agreement, and there wasn't anyone else left, and Neotel was very opportunistic when it came to negotiations. So I thought I felt obliged to see this through, as long as they remunerate me accordingly to my new employer.
Was it necessary for you to receive more money to stay?
It probably wasn't, but they didn't necessarily know that. I would have seen it through, to be honest, without additional remuneration.
They needed you. They
absolutely-
needed you.
I knew very well about vulnerability. I learned it through this process, Jay. So absolutely, they needed me like we needed Neotel.
Yes, yes. Okay.
Did you receive any payment of a bonus
I-
as part of your agreement to stay?
I did.
Please give details in relation to that.
Sure. I can't recall the exact amount, Chair. I think it was 350,000 rand paid through the Transnet payroll and tax deducted. Yeah.
And why was this bonus paid to you?
I think partially, like the Chair stated, because they needed me, and also Transnet's incentive structure. So you had something called an LTI, or long-term incentive, that would normally pay out, from what I recall, roughly in June, which was Transnet's year end was March, if I recall. So they would pay that out in June. Because I was leaving earlier now, I would not get that long-term incentive, and I would lose incentive from my new employer because I joined later. So that was what I put forward to them.
If we can then move on to the 2014 MSA negotiations and the asset buyback agreement, which begins at page 13 of your statement. It is understood that there were 2 streams of negotiation teams that were involved in the 2014 MSA negotiations and asset buyback agreement. Please provide the detail of how these negotiation teams were constituted and engaged with each other.
Sure, Chair, I think just to settle the timeline, sort of, I think we referred to the evidence by Mr. Volmink, which included that the decision was now changed back to Neotel. So now we've started negotiations with Neotel, and T-Systems was no longer the preferred bidder, which was evidenced before, like you mentioned, by Mr. Volmink. Right. So now we are negotiating with Neotel, and it was structured. There were quite a few people involved. There were 2 streams: a commercial stream that mainly looked after the Master Services Agreement, or the MSA, as well as all the terms and conditions linked to that. And there was a technical stream that looked at all the service towers, voice services, WAN or wide area network, local area network or LAN, and so on and so forth.
Please slow down. I'm struggling to follow you.
Apologies, Advocate. Apologies, Chair. So the 2 streams were structured like that, and we met at a lawyer's office in Sandton for quite a few months, in which we fleshed out this Master Services Agreement.
Which team? You say that there were 2 teams, a commercial team and a technical team. Which team were you involved in, and what was your role in that team?
So, Chair, I led the commercial stream, and there were, involvement was from Transnet Procurement, who provided oversight of the process, Transnet Supplier Development. We had an external legal, we had Gartner in the session, and then obviously a lot of people from Neotel. I think we had an internal legal representative as well. And the technical stream was led by Yusuf Lunat, if I recall correctly, again with various subject matter experts included in that stream.
Did the commercial team and the technical team engage with each other in the process of the MSA development?
We did, Chair, because we had to pull the requirements together with the pricing and make sure that the terms of the MSA supports the services. And the service towers were attached to the Master Service Agreement, so yes, we had to.
1 second. Thank you. Yes, we may proceed.
Thank you. So notwithstanding the fact that you were involved in you were leading the commercial stream, you were quite familiar as to what was happening in the technical stream as well, based on your engagement with Mr. Yusuf Lunat.
At a high level, Chair, yes. The technicalities and the detail I wasn't that close to, but at a high level we knew what the progress were and what some of the stumbling blocks were.
How exactly would you describe your involvement in this particular process?
Chair, I was extremely involved because whenever anyone from Transnet needed feedback, as an example, Mr. Singh on the process or Dr. Matuwane, it would most likely have been me that they contacted, or potentially Yusuf Lunat, but mostly me. So I was heavily involved and knew what was happening in this process.
Did you attend all meetings in relation to this process?
Probably not all, Chair, but absolutely most of them.
Were you aware of the key role players and stakeholders involved in this process?
I was.
Would it have been possible for you to have not known of any key role player in the process?
I can't see how that would have been possible, Chair.
Why?
So I think some factors to consider. Like I said, I was pretty much in every single meeting, bar maybe a few, and the Master Services Agreement was managed by our external legal consultant who owned that document and ensured that nothing changed in the document that the parties didn't agree to. So any changes would have had to go through the sessions and through our external legal consultant.
So you would have been aware of all of the material terms of the agreement?
Yes, I would.
Now, just to put it into context based on the evidence that you've already given, the background to this particular agreement is that Transnet sold its subsidiary Transtel as a going concern to Neotel, and that was about when the 2007 MSA was concluded.
That's correct.
And this particular sale included most of Transnet network equipment and infrastructure.
That's correct.
It was after the sale that Transnet found itself in a difficult situation where its IT network was owned and managed by a service provider, external service provider being Neotel.
That's correct.
And it was in the context of this background that it was now of paramount importance that Transnet needed to ensure it regained ownership of its IT network and infrastructure.
That's correct.
So during your negotiations with Neotel in relation to this 2014 MSA agreement, how would you describe the negotiations embarked upon between the parties?
I would describe it as extremely difficult, I suppose, Chair. Neotel were tough. They had a number of negotiators that didn't take no for an answer, and I think, like we discussed before, we didn't have a whole lot of aces up our sleeves. We were playing poker with an open card deck. They knew we couldn't bluff because they knew exactly what cards we had because they owned the network. So it was extremely difficult.
Did you reach a deadlock at all?
We did.
If I could take you to page 14 of your statement, paragraph 49.4, you document some of the main issues that founded the deadlock reached. Could you take the chair through some of these points, please?
Chair, so I don't want to bore you with all of them unless you want me to, but I think the main items were the pricing of the transition or that we touched on earlier, as well as the asset buyback. So as part of this negotiation, Neotel indicated that they would now be willing to sell the assets that was ceded to the bank before to Transnet as part of, and we tried to link the two so that we don't find ourselves in a similar situation. So it was crucial to us that we link the transactions and that we don't sign a master services agreement without the asset buyback agreement. Those were two of the issues. There were also parent company guarantees. We were still quite a few more detailed issues, but those were the crux of the deadlock, if you will.
Okay. Not to suggest that your offer to not bore the chair, you still stand by the points documented in paragraph 49.4.1 to 49.4.75.
I
Is
do,
that
Chair,
correct?
I do.
A meeting was held on the 8th of December 2014, and I'm now referring to paragraph 51 of your statement. Are you aware of this meeting, and how did you become aware of this meeting?
Chair, I am aware of this meeting. In the lead up to this, me being a witness and providing evidence, the investigators shared information with me that I suspect they received from the Neotel service, which indicated that there appeared to have been a meeting between Mr. Singh and Mr. Francois van der Merwe, who was the account executive, or he was in charge of strategic customers for Neotel. And it appeared that this meeting was held in Umhlanga in December 2014.
Was it normal protocol for the CFO to meet directly with the supplier?
Chair, although we don't have documented protocols in this regard, it was not normal to me that Mr. Singh, not being that involved in the process, would need to meet with the supplier's account executive. So it wasn't normal protocol, although not documented, yes.
Are you aware of a meeting that happened then on the 11th of December 2014, which is about 3 days later?
Yes, I am, Chair. I attended that meeting.
And where did this meeting take place?
The meeting occurred at the Slow Lounge in Sandton.
And who all was present at this meeting?
The attendees at the meeting was Mr. Sunil Joshi, the MD of Neotel, Mr. Francois van der Merwe, the strategic customer account executive in Transnet's case. It was Anuj Singh, the Transnet Group CFO, and myself.
So just to clarify, how many representatives were there from Neotel?
2,
That being Sunil Joshi.
and Francois van der Merwe.
Thank you. And on Transnet side, your team included how many?
2, myself and Mr. Anuj Singh.
Thank you. What exactly transpired at this meeting?
Chair, from what I recall is we went through the list of items that I referred to on the page prior, and we sort of knocked them off the checklist one by one and agreed what would be done around most of that. When it came to the pricing of the transition as well as the asset buyback, Mr. Singh and Mr. Joshi said that they'll decide and discuss that further. So they then, I can't recall if they went into a boardroom or came out of a boardroom, but they separated themselves from myself and Mr. van der Merwe, and they discussed the pricing from what I could recall on those 2 transactions, if you will.
Away from everybody else.
Yes, Chair.
Either in an adjacent room or just outside of the meeting.
That's correct, Chair. So it wasn't the 4 of us anymore. Francois and myself stayed, Mr. van der Merwe and myself stayed wherever we were. They separated themselves and they had a meeting just between the 2 of them, a private meeting, to finalize the pricing.
Was pricing the biggest issue
In my
between
mind,
the parties?
in my mind, Chair, yes, it was.
So, Mr. Anuj Singh and Mr. Sunil Joshi leave the room where you and the other gentlemen are in. They have a private discussion and they return.
That's correct.
Are you informed about what happened in the private discussion?
Chair, at some point we must have been, although I can't clearly recall the conversation, but that was, as the advocate mentioned, on the 8th of December, and we subsequently finalized the master service agreement with the pricing on, was it the 13th of December? So at some point, Mr. Singh needed to give me feedback that go ahead and get this agreement done, and this is the pricing that we've agreed.
At paragraph 54 of your statement, you inform that no feedback was provided to you after the meeting between Singh and Joshi. But at some point during the 11th or the 12th of December, you must have been instructed to meet on the 13th of December to finalize the MSA.
That's correct.
Did you in fact meet on the 13th of December 2014?
We did, Chair. If I recall correctly, it was a Saturday, and we met at the Neotel's offices to finalize the Master Services Agreement.
And who was present at that meeting?
Chair, multiple people, but Mr. Joshi, myself, I think Mr. Abid Kadri, who was one of the negotiators from Neotel. Mr. Van der Merwe wasn't there. I think he's already left for holiday at that stage. And then I think it was myself and our external legal consultant who, like I said, owned this MSA. We couldn't get any takers on Saturday.
Had you prepared any documents for this meeting?
We didn't prepare any additional documents. The documents, like I said, would have been owned by our external legal consultant, and she would have had all the documents there on her computer.
Differently stated, did you present any document at this meeting?
The MSA, our external legal consultant, would have presented there for finalization and printing for signature later.
So being involved in this entire negotiation...
I'm sorry. Did you mean to ask whether he made any presentation, or did you mean whether they gave the other people some documents?
I
When
did
you
actually
ask
ask
whether
a
they
presentation.
presented,
Yes,
which one did you mean?
presented
Presentation, whether they made a presentation. Okay.
on the document.
Is your answer valid if that's the understanding?
Chair, I
So
suppose
she was asking whether you made a presentation at the meeting?
we basically just pulled up the Master Services Agreement and made final adjustments to them as agreed in the session between Mr. Singh and Mr. Joshi, and myself and Mr. Van der Merwe. In those two sessions.
And Basil talked to the documents
Yes.
and gave them copies,
So
or not necessarily?
Chair, if I recall correctly, at that stage, it was a day before I was leaving Transnet, so I think I've already handed in my laptop. So I think
Yes.
we sent the documents to Mr. Joshi, if I recall, who then printed a set of documents which I presented to Mr. Singh on that day for final signature.
Okay, thank you.
So the agreement was then in final form.
That's correct, Chair.
You said that that was your last day of employment at Transnet,
That's correct.
and this was on the 13th of December 2014.
Yes, so I can't recall if technically I was still employed up till 31 December, but that was the last day I attended it, and I was on leave thereafter. So that was the last line of business, if you will, that I executed on behalf of Transnet.
Just going back to your involvement in this particular process, you mentioned that you were involved in all of the formal negotiations relating to this transaction. Were you involved in all of the informal discussions on it as well?
So, Chair, I believe I was a part, I don't know what I don't know, but the only two informal sessions that I'm aware of that I wasn't involved in was the apparent meeting between Mr. Van der Merwe and Mr. Singh in Umhlanga, and the separation meeting at the Slow Lounge where Mr. Joshi and Mr. Singh finalized the pricing, from what I recall.
Okay. Then to summarize, and please correct me if I'm wrong, to summarize, you led the commercial stream of the negotiation team.
Correct.
Yusuf Lunat led the technical stream of the negotiation team.
That's correct, Chair.
You had your external lawyer, who
That's-
was the master of the MSA.
That's correct, Chair.
The commercial stream and the technical stream engaged with each other to keep each other abreast of the regular updates.
Yes, we did, Chair.
You were aware of all of the changes to the MSA.
I believe I had to be, Chair, since our external legal consultant owned that document and would have checked any changes with me.
Would it then be a fair statement to say that the negotiations and the detail of those negotiations on paper was always present to your mind?
I would say that's a fair statement, Chair.
And so you were fully aware of the negotiations and the outcome of those negotiations as documented in the final MSA, which you presented for signature on the 13th of December 2014.
I believe so, yes.
Now, who is Homix?
Chair, so the first time I heard the name Homix, I think, was 5 or 6 months after I left the employ of Transnet. And I read about a company called Homix in, if I recall, it was Amabungane's release in the papers. I also had a gentleman, now that I think of it, Mr. Stefans Brummer from the Sunday Times, phoning me a day or two before that article was released, asking me if I was willing to talk to him, which I said I was, if Transnet was willing to release me from confidentiality. But that's the first time I heard the name Homix.
Did you encounter, not to take away from your evidence that that was the first time you've heard of the name Homix, just for the avoidance of doubt, did you come across the name Homix at all during the 2014 MSA and buyback agreement negotiations?
I did not.
If I could take you then, before I do take you to a paragraph, I'm not sure if my time is correct.
Well, we are 6 minutes to. If we can, we can exhaust the 6 minutes and then
No
take
problem.
the lunch break. But if it's more convenient to continue after lunch, that's fine.
Could I beg an indulgence just to
Okay.
clarify certain aspects
Yeah.
before we get into this detail?
Yeah, okay.
Thank you.
Okay, you want to do that after lunch or now?
I beg the indulgence to have the lunch break, the long adjournment now.
Or that we take it now?
I'll really
Yeah,
appreciate it.
that's fine. Okay, we'll take the lunch adjournment now, and we will resume at 2 o'clock. We adjourn.
Hmm?